AAC R4281101B establishes one of the most important ethical and legal duties for Arizona real estate professionals: the duty of full disclosure. This rule requires that all licensees disclose to every party in a transaction any material fact the licensee knows that might affect a party's decision to buy, sell, or lease property. Material facts are those that would influence a party's judgment or the amount of consideration paid. Failure to disclose such information can result in disciplinary action and civil liability. The Arizona Supreme Court case, Jennings v. Lee, 1969, firmly established that a real estate broker or salesperson owes a duty of full and honest disclosure of all material facts known to them. In this case, the court emphasized that agents must act in good faith and cannot conceal or fail to disclose information that would influence a party's decision, even if that omission benefits their client. This decision reinforced the ethical foundation that licensees must prioritize honesty and transparency in every transaction. Under AAC R4281101B1, a licensee must disclose any information that might affect a seller's ability to perform under the contract. This could include known financial hardship, bankruptcy filings, or title issues that may prevent the seller from transferring clear ownership. Ensuring all parties are aware of such issues prevents delays, litigation, and contract breaches. AAC R4281101B2 extends that same requirement to a buyer's ability to perform, meaning that if a licensee is aware the buyer lacks financing approval, has credit issues, or cannot meet contractual terms, the licensee must disclose that information to the other party. Concealing such facts would mislead the seller and could result in a violation of professional conduct standards. The Arizona Supreme Court case, Lombardo v. Albu, 2000, further clarified the scope of disclosure. In this case, the court held that a seller and their agent have an affirmative duty to disclose known defects that materially affect the property's value. The court also made clear that as-is clauses do not protect sellers or licensees from failing to disclose known material defects. The case strengthened consumer protection and reinforced the broker's role as a professional fiduciary. AAC R4281101B3 requires disclosure of any material defect in the property. Material defects are physical or environmental conditions that substantially affect the property's value or desirability. Examples include roof leaks, structural damage, flooding, mold, or faulty electrical systems. If a licensee is aware of these issues, disclosure is mandatory, regardless of whether the buyer asks about them. AAC R4281101B4 mandates disclosure of any known liens or encumbrances on the property. This includes mortgages, mechanics liens, easements, or judgments that could affect title or ownership rights. Disclosure of these issues is vital to ensuring clear title transfer and avoiding post-closing disputes. The Stigmatized Property Law, ARS, Paragraph 322156, protects sellers and licensees from liability for failing to disclose non-material psychological stigmas associated with a property. This includes deaths, suicides, crimes, or the presence of individuals with HIV/AIDS. Arizona law distinguishes between physical and psychological defects. While material physical defects must be disclosed, stigmatized property facts are not considered material and are not required disclosures. Finally, AAC R4281101 governs compensation disclosure, requiring licensees to disclose in writing to all parties who is paying them and whether they will receive compensation from more than one party in the same transaction. This rule ensures transparency and prevents conflicts of interest by keeping all parties fully informed of the licensee's financial relationships.